Hi, I'm Mark Mancini with VRBO Outstanding. In this week's episode, we're going to talk with Shannon Collier, who is an attorney in Georgia and Florida. So welcome back. This week, we're here with Shannon Collier. Shannon, I've used for about 15 years. She's licensed in both Georgia and Florida, which will help a lot of you guys out. And before we really get into our conversation, which is not any legal or advice by any means, this is just a conversation amongst professionals. I want Shannon to kind of introduce herself and give her a little bit about her background.
Thank you, Mark. It's good to see you again. So, yes, as you said, I am licensed in Florida and Georgia. I got my law degree back in 93. So this means 30 years of practice this year. And then I went on to Emory to get my LLM in taxation. I have a background also in business and accounting with a finance degree from a small public school in Florida that, some people might know. But no, not a Gator, not a Gator, never a Gator. But I primarily practice business transactional, tax planning, all the fun stuff.
Well, you shared your years of graduation. I was just going to say we've known each other for professionally for 15 years, and we started when we were 20, but you blew the whole thing. So
start when I was 20. I could have graduated law school, when I was 12. And,
There you go. Well, I kind of want to start on something that I think is the backbone for everything. I've always been an advocate of the phrase, good fences make good neighbors, right? And so I use a software system for my management of my properties called OwnerRez, and they offer a great starting point for a rental agreement. And it is just that, a starting point. So I put in some of the stuff that we have with our property, like kayaks and bikes in the pool, et cetera. But what I did was I gave it to you to review and make sure I was protected. So how important is it really for an attorney to review these rental agreements to make sure that, because I'm not an attorney, tell us more about what the importance is of that and the importance of a signed rental agreement.
Oh goodness. Oh, so you're hitting a sensitive spot for me. I don't want to say that someone could not create a document on their own using all the wonderful resources that are out on the internet and on private software services today. However, the point is those are not just like our talk today. It's not legal advice. Those documents are not put out as legal advice. Clearly, they declare that. So what they've done is they've created just some boilerplate generic information that they decided to put in for whatever reasons that may not consider all the what ifs. I always say, I am the devil's advocate. That's my job. It's what I'm paid to do. So they don't go through all the what ifs. They don't consider all the differences in state laws. They don't know the most recent holdings that might have been held in court cases that attorneys use to keep their documents. I say documents are living, breathing. So, Mark, you retain me to do your document. What's going to happen is in 12 months, I'm going to reach out and say, Mark, by the way, there was just this big case, or I was just in this case, and the judge made this point, or the jury made this point, or this was the holding. Let's put something else in your document that accounts for this contingency. So attorneys may know of some of these contingencies that aren't in these blanket forms. So that is a difference between seeing a form that you might get on the internet or that your friend gave you that their attorney drafted, or that you got in a CRM. Similarly, if those documents aren't signed, then they are absolutely of no good whatsoever. You have a will that's not signed, you've done nothing. You have a contract that's not signed, you have done nothing. So you are wide open to whatever the statutes are. And the statutes are silent on a lot of remedial possibilities that you are given in a contract. So where you might be given 1, 2, 3, 4 that you can do in a contract, a statute is completely silent, meaning you don't have any of those rights you would otherwise have to enforce your rights, to enforce the agreement and to collect your money or to recover damages or to enforce behavior on the behalf of somebody else.
You mentioned a couple of things that I want to circle back with. And some of our short-term rental owners have properties in more than one state. So the great thing is you're in two contiguous states, right? Georgia and Florida. But I mean, for those who may have a rental in Florida and one in Alabama or South Carolina, I guess it's pretty important because, as you just said, the different laws and cases in each state to make sure those little nuances with pools or kayaks or bikes or even just liability in general is addressed in each of those states. So they need attorneys in multiple states.
It is very likely that they do. An example is in Georgia, horseback riding is deemed an inherent risk. Often four-wheelers are deemed inherent risk. The thing is in your state, is the kayaking or is the skiing or the snow, the boarding or the jet skis, or are there certain disclosures you have to make to have the inherent liability statute apply to you? And this does vary state by state. So liability coverage can be different depending on where you are.
And you mentioned signature, which I think is important. So we do DocuSign for our signatures. Is that fine, or do we have to have a physical signature?
Yes, especially now since COVID, electronic signatures have definitely become more acceptable. You just want to make sure that your DocuSign, of course, has the immediate copy receipt being sent to the party signing, because you don't want them coming back and saying, well, I never got a copy of my document. Well, yes, if you look at my DocuSign record, you'll see that it was sent to this computer with this ID, and that is your computer, isn't it? So you do have a copy, but there are only a few documents now that have to be wet signed, and contracts are not one of them. So that's the great thing is you can operate freely among states electronically and get things done quickly and efficiently.
That's awesome because, like I said, the software I use has it built in, and that's one thing they've had for a while that I love because it stores it in for that particular person. I can look at my list and see who signed it yet and who didn't sign it. But suppose you have someone who books maybe through Airbnb or VRBO, because I have them sign it even though they're going through those platforms, not just direct book. I have all of my guests sign the RA. Suppose I get someone from Airbnb or VRBO who doesn't want to sign it. Should I still take that booking, or should I? What would you? Well, without giving advice, is that something that I should be careful of?
I would say it's reflective of the amount of liability and risk you are willing to assume.
Now, speaking of liability, I assume having the signed RA rental agreement does help prevent against maybe frivolous lawsuits, possibly, and kind of mitigate some things that maybe maybe extraneous.
Today's society, I don't know if anything prevents unnecessary or frivolous litigation. People will file in magistrate court for nominal amounts, not realizing that the document is totally clear or believing that they're right regardless of what the document says. Maybe if they go to the judge and plead that case, that the judge will fine for them because they're so pitiful, when in reality it is still the government, it's the document that governs. So it is important, but does it stop litigation? No. Does it reduce it? We like to think that people have enough common sense that it does help mitigate. But in the end, the primary objective is that you have a document to present to the court to state clearly, and even more so if they retain opposing counsel, you have a document to present to legal counsel that says, look, this is clearly defined in the agreement. We are clearly within our rights. Therefore, if you pursue it, you know that you're acting frivolously and you personally can be sanctioned for this. So that's when it becomes really fun.
And I guess too, I guess what I probably should have prefaced it with is what through your advice was always to have a kind of a what if. So no smoking is allowed in the home. If you were caught smoking, there is an X number of dollar penalty, right? If a dog is brought in and we weren't notified, the pet fee applies. We're going to take it out of your deposit. You always want to make sure that if there is any kind of breaking of rules, that if there is the ability for a financial fine, so to speak, that we have that in there, disclose to them ahead of time so they can't, well, I didn't know, right?
Well, and not only that, but that you have the right to charge the credit card on file for it. Because what good is that they owe it if you can't get to it? Now, again, it doesn't mean they won't contest the charge, but you will show that the terms of the contract were clear and that here's the evidence of destruction. They clearly brought the dog in. They clearly smoked in the premises or the like.
And going back to the Airbnb and VRBO, the way I look at them is they're middlemen, kind of like eBay, right? They put together a buyer and a seller and make a transaction. So that's the way I view them. So in their mind, their transactions with the guest and with you. But since you're offering the service, isn't there a transaction in a sense between you, or it would? And what I'm going at is the rental agreement is designed really to protect both the guest and the owner, because otherwise you're going through the intermediary, which sometimes is not the best way, right?
Remember, the intermediary doesn't really represent either of you. Like you said, he's the middleman, he's the agent, he represents neither of you. So while he may have a contract and the objective may be to make you feel better about renting through him, it doesn't mean that he's taking all of your interests into consideration and implementing the same for your benefit. To the contrary, he probably wouldn't, because then he feels he'd scare off more of his potential other side acquire, interested parties.
Gotcha. Now I know what I do, what I advise and what I do is in my listing for Airbnb and VRBO, I say that there is a signed rental agreement that is required, but I also note in there that they can review it before they book. This way they can take a look at it. Do you have any issue or reason why you shouldn't show that to the guest? I mean,
No, I would rather you do it. So that would be it reduces the likelihood that it be deemed a contract of adhesion, which it probably is anyway. But if you made it so that after you book, you have to sign it, it's definitely a contract of adhesion, which gives you, in certain states, it pulls in other laws that may apply. It also pulls in possible federal laws. So to make it so they have the opportunity to review it and that they've made the decision after reviewing it that they still want to proceed, they had complete discretion whether or not. So it definitely works to your favor to let them see it. Moreover, if they're going to fight you on the back end, you don't want them as tenants or as guests or whatever you call them at that point. But it's definitely, you have nothing to lose, but again, possibly the liability that you did not want to assume.
gotcha. Now, hypothetically, this is
Totally hypothetical.
I want to put unicycles at my rental for people to use, which are probably the hardest thing to ride, right?
Your lawyer advises against that.
Lawyer advises against. If I were to do that, I assume I shouldn't just put this in. You're waiving your rights myself without having you review it first, right? So always, whenever I make a change, I should run it by you. Correct? Just want to make sure I'm clear about that.
I mean, it's one of those things where for me, the 30 years been in practice, when the client tends to integrate something without reaching out to me, they tend to end up spending more after the fact. And I'd much rather protect them than not. This is not a matter of, oh, I want a nickel and dime, or, oh, great, it's more work for me. This is oh my God, please don't let me have to get you on the other side.
Absolutely.
So anything that can create additional liability, I'd much rather make sure you're protected. And I may have said, no, we've already got the general activities covered. I'm not worried about that unicycle being added. We already had jet skis, we had horseback riding, we had whatever else. We're good. Or I may have said, you know what, let's just add a couple words. Let's just that, CYA.
Gotcha. And also, too, for some people who may not be as familiar, because I've been doing this a long time, I've seen a lot of things. If someone were to try to litigate against you, okay, where would that take place? Would it take place in the county or city where the rental is? Is it where they are? What's the jurisdiction for something like that?
If not declared otherwise, the default jurisdiction would probably be where the property lies, because you can do it where the tort arises and it arose at the location. Now, if they are suing an entity, you have an LLC that is the landlord, the rentor, then the registered agent gets served and it's that jurisdiction, wherever the registered agent is. So let's just say I'm the lawyer. So I'm in Cobb County, Georgia. So if you were sued ABC Corp or ABC LLC, they say, oh, well, Shannon in Cobb County is the registered agent. So we have to sue in Cobb County. So that would be that. Now, going to the fact there's an agreement, the agreement gets to define it. So if they've signed this agreement and you've got a venue and jurisdiction clause, not only says what law governs the agreement, it says where litigation has to take place. So we may say, hey, Mark, your LLC is here and I'm here, but you are in South Carolina. So we made the jurisdiction X County, South Carolina. So we can define it. So statutory default is typically where an entity is the registered agent. The other default is if you don't know or you're not sure, or another permissible is where the tort arises, unless, of course, you have a governing document, in which case the governing document governs.
So that's definitely something to consider, because you have people who have rentals in different states that they live in. At the same time, you also want to make it inconvenient for the person suing you, so they have to travel and get a hotel stay, etc. But you also don't want to make it inconvenient for you. So maybe in a situation like this, you do have it in some other place that is more advantageous for you, defined in your rental agreement, so that they're less apt to do something litigiously that would be a pain in the butt for them, right?
That is a strategy to consider. But remember also, it may be convenient for you, but it may not be convenient for your counsel. And the last thing you want to do is pay for your counsel to travel.
Well, Shannon, you're always welcome at our vacation rentals, because you've been such an awesome attorney after all these years. I still maintain you started practicing when you were 10. That's like you've been doing this for 30 years.
I am totally aboard with that theory.
Well, we've talked about a good deal with rental agreements, and that's a great groundwork. And I appreciate your time here. What I'd like to do is reconvene next week, and let's talk about liabilities, LLCs, because that's a whole nother episode we can go on. So thanks again for your time, Shannon.
Thank you.
And don't forget, hit the like and subscribe button below. We'll see you again next week.